You're watching The Legal Breakdown. So, Glenn, we've got a hugely consequential update in the case to disqualify Donald Trump from the ballot in Colorado. So, as everybody knows, a district court judge ruled recently that while Trump did incite an insurrection on January 6th, that he wasn't barred from being placed on the primary ballot. That decision's now been appealed to the state Supreme Court. So, Glenn, what's happened now?
Yeah, so there was something for everybody to dislike about Judge Wallace's ruling. Trump did not like the fact that the judge, after a trial, after hearing from witnesses who were at the Capitol on January 6th and other witnesses, for example, experts on the Constitution, she ruled, as a matter of fact, that Donald Trump engaged in an insurrection, a really consequential ruling. Donald Trump didn't like it, so he filed a notice of appeal. Now, the voters of Colorado didn't like the second part of Judge Wallace's ruling, which is that even though Donald Trump engaged in an insurrection, I'm not so sure that under the terms of the 14th Amendment, Section 3, that he should be disqualified, because I'm not quite sure if the office of the president is a federal office. Let's not try to make sense of that one. But both sides ended up appealing. And so they just conducted the oral argument in the appeal before the Colorado Supreme Court. Both sides argued their case. By all accounts, I read a number of accounts of how the arguments played out. The 7 judges on the Colorado Supreme Court were not really tipping their hand much in their questions, although there did seem to be a consensus, at least among the reports that I read, that it does seem like they're pretty clearly convinced that what happened on January 6th is, in fact, an insurrection. That's a really consequential ruling in the event they make it, and they affirm Judge Wallace's ruling in that regard. But it sounds like they didn't really tip their hand on whether they were prepared to say the 14th Amendment, Section 3, stands for the proposition that if you took an oath to support the Constitution and thereafter you engaged in insurrection, you cannot be president. That is still the question we have to wait for the Colorado Supreme Court to answer.
And to that exact point, when can we expect that ruling from the Colorado Supreme Court?
Soon. By all accounts, there was some discussion during the oral arguments about the urgency of the moment and how this issue has to be resolved very promptly. Wouldn't shock me if we saw something as early as maybe early next week. Perhaps, 24 hours is a little much to expect from a Supreme Court, but I think within days, we're going to see a ruling.
Okay, and then, of course, how long until this is inevitably appealed to the U.S. Supreme Court?
Inevitable is the right word, Brian, because I think whichever side wins, whichever side loses, there will inevitably be an appeal. Listen, if the Colorado Supreme Court says Trump cannot be on the Colorado state ballot for the 2024 presidential election, you can bet Donald Trump and his lawyers will appeal that. Similarly, I think if the voters of Colorado lose and the Supreme Court says, yeah, we believe Donald Trump engaged in an insurrection, but we're not going to disqualify him because there's some uncertainty in the language of the 14th Amendment, I would fully expect the Colorado voters who brought this suit to appeal that. And then the question becomes, does the Supreme Court accept the case for review? And I think some of that might depend on who wins and who loses.
Well, on that point, what are the implications if the U.S. Supreme Court opts not to take this case?
Yeah, that's a great question. If they decline to take the case, then whatever the Supreme Court of Colorado ruled will stand. It will only impact Colorado. It won't impact the other states. Each state is sovereign. They can make their own decisions about their laws. But it really does depend on which way the Supreme Court of Colorado rules. If they rule against Trump, they say he can't be on the ballot, and the Supreme Court decides not to accept that case for review, then that law stands, that decision stands, and Trump will not be on the ballot in Colorado. Conversely, if the Supreme Court of Colorado does not disqualify him from the ballot and the United States Supreme Court declines to take that decision for review, then the people of Colorado are going to have to live with Donald Trump as a presidential candidate and former insurrectionist on the Colorado ballot.
Well, if the U.S. Supreme Court opts not to hear the Colorado case, and we have other cases along these same lines being litigated in states across the country, is it possible that in one state Donald Trump may be on the ballot, in another state he may be kept off the ballot? I mean, doesn't that create some type of like untenable situation that we have in the states?
Yeah, wild inconsistency among the states on this issue is not good for anybody, quite frankly. I don't think it's particularly good for our democracy. So that prompts me to strongly suspect the Supreme Court will grab hold of one of these cases. One of the reasons the Supreme Court will exercise jurisdiction in a case is if there is what's called a split in the districts. If one federal district decides an issue one way and another federal district decides the issue another way, the Supreme Court has a keen interest in taking those cases, consolidating them for review, and then decide it, because it really is important, setting aside the sort of quality of the judgments we're getting out of this Supreme Court. It really is important for the Constitution to only be interpreted, with one voice,
Okay.
having one meaning throughout the different federal jurisdictions. I think the same applies by extension to the states. When you have something as consequential as whether a person can be on a presidential ballot or not, yes, it's up to the 50 states to administer their state election laws, but I can't envision the Supreme Court not accepting review of this and wanting to put one word out about what the 14th Amendment's disqualification law and clause means. Does it mean that if Donald Trump engaged in insurrection, he can't be president again? Or does it only mean he can't be a member of Congress, or he can't be a member of a state legislature, which makes absolutely no sense. So I think at the end of the day, this is going to be one for the U.S. Supreme Court.
Now, assuming the U.S. Supreme Court does opt to take up this case, do they have to rule on this before the ballots are set to be finalized, which may be sometime in January?
You really can't push the Supreme Court to do anything it doesn't want to do. We learned that when there was this enormous clamor for a code of ethics, and instead they issued a pamphlet of suggestions that don't resemble a code of ethics at all.
Right.
So, but I do think, all snarkiness aside, I do think the Supremes are going to be keenly aware of the time constraints here. And look, we have seen them act promptly previously, like during the Bush-Gore election challenge. So I have a feeling they're probably already thinking about this issue. They probably already have a preconceived notion of whether the 14th Amendment, Section 3, disqualifies Trump or not. And I have a feeling we will see a ruling from the Supreme Court at what for them constitutes light speed.
If the U.S. Supreme Court, again, does opt to take up this case, does that mean that all of the other ongoing lawsuits related to Section 3 of the 14th Amendment will kind of defer to the ruling handed down by the Supreme Court?
I think that will be the practical consequence of the Supreme Court accepting review of this issue, because the states can still conduct their trials, and depending on the way the trial court judge rules, as Sarah Wallace ruled in Colorado, the parties can appeal it. They can go through the motions. I think it will be kind of a pointless exercise, though, because in the event the Supreme Court of some other state rules in a way that is inconsistent with what the Supreme Court has said about the interpretation of the 14th Amendment's disqualification clause, it will kind of all be for naught, because the state courts will, in essence, have to fall in line and defer to the Supreme Court ruling.
All right, and let's finish off with this. Glenn, I know you're not a betting man. I know your betting limit is $1. So let's put the dollar on the line here. If you had to guess, how would you say that this issue is ultimately resolved if and when the U.S. Supreme Court does take it up?
Oh, I have to take a deep breath and try to keep my blood pressure down, because I am conflicted. I want desperately to see our democracy, I don't know, survive.
Yeah.
And the way our democracy survives is if insurrectionists are not permitted to retake the reins of power.
Imagine that.
That being said, I'm not wildly enthusiastic about all of the Supreme Court justices doing the right thing in all cases. I'm going to go out on a limb. I'm going to bet 51 cents I always hedge my bets when I'm not sure, because if I'm wrong, I can say, well, 49% of me, said the other thing, and I get to keep 49 cents of
That's
my
right.
bet. I'm gonna bet 51 cents on the Supreme Court saying the plain language of the 14th Amendment, Section 3, disqualifies Donald Trump because he engaged in insurrection after he took an oath to support the Constitution. That's where I'm going to put my 51 cents.
Okay, well, obviously we'll have some resolution relatively soon because this thing really can't languish that much longer. So if those watching want to stay on top of this issue, please make sure to subscribe. The links are right here on the screen. I'm Brian Taylor Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.